the demand and insistence that the request Justice Bianta Nyako will no longer continue his trial by Mazi Nnamdi Kanu has indeed paid off, as the Chief Judge of the High Court reassigned a new judge to continue the supposed trial. Now the question is, what else will Mazi Nnamdi Kanu be tried, as he has made it very clear that the Nigerian court has no jurisdiction to try him because the alleged crime or treasoning or whatever it is was not done within the Nigerian jurisprudence. And being that Mazi Nnamdi Kanu was renditioned 2021 and was subjected to trial under the Nigerian law, which violated the international treaty and diplomatic treaty and laws bordering on extradition. Being that he is a Britain citizen traveling with a British passport, and eventually he was bundled from Kenya down to Nigeria, blindfolded to continue the trial, and eventually was summoned. And ever since then, there have been charges levied against Nnamdi Kanu, which eventually was reviewed on several occasions, and yet the legal counsel to the Nigerian government could not substantiate or argue their case against Mazi Nnamdi Kanu, that prompted the 6 panel judges that was set to review the case, of course, struck out the count charges, the 15 count charges as amended, and then declare Mazi Nnamdi Kanu acquitted, citing that the Nigerian government has no rights or lacks the jurisdiction or legal rights to subject Mazi Nnamdi Kanu to further trial, that he should be discharged and acquitted. Being that, again, the Supreme Court affirms that Mazi Nnamdi Kanu do not jump bail, contrary to the position or argument of the Nigerian defense. And eventually, the Supreme Court has to set the record straight, indicting the Nigerian government to have attempted, of course, assassination of Mazi Nnamdi Kanu, which led to him calling for safety. And there is no law that, of course, stops Mazi Nnamdi Kanu for fleeing for his life, as he is being threatened in the face of such threat. And eventually, after his extraordinary rendition, Nigeria have not explained reason why he should be renditioned in such a manner after being tortured for 8 consecutive days. It is quite very unfortunate. Under the watch of Buhari as the president of Nigeria, Tinubu has also resumed office as the executive president of Nigeria and decides to continue this trial, set aside the verdicts of the appeal court, which upheld the innocency of Nnamdi Kanu, squashing or setting aside all the count charges. And Tinubu has to set aside, of course, raise another counter notion to set aside the same courts giving 2 different judgments. The same court giving 2 different judgments. Now, it means that the court is at war with itself, and this is quite unfortunate, and people have been expressing such level of doubts and confidence in the Nigerian legal jurisprudence. How would the same court giving different orders, and the state of execution is quite unfortunate too? There have not been any other count charges filed against Mazi Nnamdi Kanu, or could the previous charges that was quashed, that has no basis, be resurrected again? So that has been the question. Well, Mazi Nnamdi Kanu legal counsel have said that they are not afraid of trial, but what they are afraid is injustice. And now that another lawyer or judge has been reassigned this case, and eventually the case will possibly resume if there is any case or trial in this regard. But whatever happens, there have been several calls internationally and locally demanding for the release, unconditional release of Mazi Nnamdi Kanu. Since the Nigerian courts has set him aside, squashed all the count charges, then what else could he be charged for? That is quite interesting. Well, time will reveal otherwise. And of course, Mazi Nnamdi Kanu have expressed deep confidence that he must get justice, and he has not committed any known crime under the Nigerian law, that self-determination is not a crime. As Nigeria being a signatory to the United Nations Charter on Human Rights and the right to self-determination. So as such, of course, he has also argued, even within the court, that it is his fundamental right to agitate, which does not contravene any known law internationally or locally. But then, let's see how, or whatever Nigerian government perhaps may think they have against him, in the same court that set aside all the count charges and set him free and acquitted, eventually there was a violation or non-compliance to that rule of law or verdict that was ruled in his favor, which Buhari then said that he will not interfere, let the court has its, of course, way, and eventually the court did, setting aside the count charges and declaring the innocency of the accused, and eventually no justification for his continued detention. Well, let's see how far this could go. Would that be an expedite hearing or whatever? Or could they also deploy the means of tactical delay and adjournment upon adjournment and amendment and amendment of whatever, which I don't think there could be any different charge against him. Perhaps they may go back and dust the previous charges, as a state of execution order was raised in that regard, which means they want to start afresh ahead again, just to buy time and possibly continue the illegal detention of the leader of the indigenous people of Biafra. For some persons who describe the IPOB as proscribed, well, of course, that would be mischievous. Well, I don't bother to discuss that. The legal counsels through Mazi Nnamdi Kanu and the IPOB, of course, has to address such developments.